May it please the court, my name is Larry Florentin. I represent the appellant, Yana Smith, in this proceeding. I would like to reserve 5 minutes for rebuttal.
Sure.
We would like to focus on the issue of subject matter jurisdiction in this case. The trial court adjudicated rights and obligation of the party with respect to properties located in Montana. The former husband filed a petition for dissolution of marriage, which includes 17 different counts, including fraud, misrepresentation, fraudulent misrepresentation, negligent misrepresentation, conversion, exploitation, and a demand for jury trial. But he also requests a change in title with respect to property located in Montana. Our position is that if there's going to be a request for a change in title, the local action rule applies, and it requires that suit be brought in the county where the property is located. Now, we admit that the trial court has in personam jurisdiction. It can distribute property, all the property of the party. However, in this case, the request for a change in title was not incidental or ancillary to the divorce proceedings, because on one hand, you ask to rescind deed due to fraud, or rescind deed for lack of capacity, for duress, but these are independent claims. These are claims that could be brought independently from a divorce proceedings. If the former husband wanted the trial court to distribute all property, he could simply just file a petition for dissolution of marriage and partition, and that's it. The trial court would have had jurisdiction in personam jurisdiction, and any decision would have been incidental to the divorce proceeding. But that was not the case in this case. We maintain that the decision was in error, and which is prejudicial to the appellant, because the trial court awarded the Montana properties, and the finding was based on the husband lack of capacity, the wife undue influence, fraud, and coercion. These are independent claims. These are not claims dealing with divorce or equitable distribution or anything dealing with the divorce. These are claims that can be brought independently. We believe that this issue has been fairly presented in a brief. We request this court to reverse on the subject matter jurisdiction, because the trial court did not have the power to adjudicate claims outside Florida, since the request to change title was not part of, was not incidental or ancillary to the divorce proceedings. Now, we would like to focus on the trial court striking former wife pleadings and entering a default. Now, we do know that Florida public policy favors an adjudication on the merits as opposed to the entry of default. While it is appropriate for the trial court to enter a default for discovery violation, but this has to be employed in rare circumstances. We do know that there were some problems with respect to discovery. However, the former wife did comply with the others. In fact, even the former husband admitted that many of the motions and the trial court orders on discovery overlapped. So we do know that the former wife responded to discovery, the first request for production. She did not file any objection. She responded to all the questions and turned over all the documents in her possession. She supplemented the first request, her responses to the first request for production. She responded to the second request. She supplemented her responses. Also, with respect to the order on accounting, she responded to that and supplemented that request with documents she translated, with bank statements, all that. Now, we cannot say that the former wife did not comply with discovery. Of course, there are issues But this is not a case where she willfully did not comply whatsoever with discovery. In fact, we do know that the former wife attended 7 hours of deposition. 7 hours of deposition. So she, the deposition was adjourned because she ill the first time, and then the second time she attended 5 hours. Now, the order striking her pleading was too harsh because this is not a case where she did not comply at all. We believe that if the trial court was concerned about undue expenses, for example, in the order striking pleading, the trial court made a finding that the discovery violation was an undue burden on the former husband. But if the trial court was concerned about undue burden, it could have at least imposed sanction in terms of fees and costs associated with the violation. But in this case, it simply struck the former wife pleadings and entered a default against her. The decision below was replete with errors, including the failure to rule on the former wife motion to continue. That was a due process violation. The former wife was not given a meaningful opportunity to present a full and complete case, because after the former wife counsel filed a motion to withdraw, the former wife believed that counsel already withdrew, filed a motion to continue because she wanted to be there at her divorce hearing. When that issue was presented to the trial court refused to rule on the motion. Even counsel for former husband stated that the motion to continue was on the docket, and she was concerned about the fairness of the proceeding and begged the trial court to rule on the motion. The trial court refused to do that. In fact, the trial court stated that former wife does not have any say-so in this matter. But just because there's a default, that doesn't mean the former wife cannot be at her divorce hearing to present evidence on damages. Because we do know that even after a default, a party has a right to present evidence on damages. In this case, we do know that the trial court entered a money judgment against the former wife, putting aside all the other issues dealing with legal claims that requires testimony, but on damages, the former wife was entitled to present evidence on her behalf. We do know that the underlying cause for the continuance was unforeseen by the former wife, because it was her attorney who filed a motion to withdraw 2 days prior to trial. We understand that the trial court want to finish with the divorce proceeding. However, where the former counsel filed a motion to withdraw 2 days prior to trial, it is reasonable for the former wife to seek a short continuance just to present her case. And a short continuance would not have prejudiced the former husband. And again, regardless of a default, the former wife has a right to contest damages, and she was prevented from doing that in this case. With respect to the issue regarding jury trial, we are here today because the former husband filed a petition and 17 different claims, legal claims, and requests a jury trial. But once a jury trial is requested and there is no request to withdraw the demand for jury trial, the party are entitled to a jury trial. But in this case, there was no jury trial. Now, we do know that there are a number of different claims, legal claims, that require a jury trial. For example, you have fraud, fraudulent misrepresentation, negligent misrepresentation, conversion, exploitation, and in addition to damages. Now, the legal claims, for example, for equitable distribution, or let's say for rescission of deeds, rescission of prenuptial agreement, postnuptial agreement, these are equitable claims that do not require jury trial. But under the law, when legal claims are intertwined with equitable claim in the same complaint, a jury trial can be awarded for all those claims. Now, we do know that the former husband filed a legal claim for fraud, and even if rescission is an equitable claim, under the law, notice of rescission requires factual findings. So in other words, the elements of fraud and notice of rescission, the court is required to make factual findings. If there is a jury, it is the jury's job to make those findings. But let's assume that there was no jury trial. It is for the trial court sitting in bench as the trial fact to make those factual findings. In this case, there is no evidence in the record with respect to the transcript or the final judgment itself that the trial court made factual finding with respect to the element of fraud and notice of rescission prior to making a decision on the rescission claim. Now, we do know that a jury trial is a constitutional right, so it should not be infringed upon just because someone has a default against one, especially even with the default, even if the former wife was not present at the trial, unless there is no objection. But usually the appellate court would reverse even if the trial court, even if a person is not present at a trial once a jury trial is requested. But in this case, there are a number of different issues dealing with legal claims that require a jury trial, and we do know that the former wife wanted to be present because she filed a motion to continue just to be present to hire new counsel, because this is a high-stake case. This is a complicated case with 17 different counts. Someone with no legal background would want to be present at her divorce proceedings. Now, because the legal claims and the equitable claim were intertwined, the former wife was entitled to a jury trial on all those claims, but she was denied that opportunity, and this is for this court to correct this error, because a constitutional violation is always prejudicial. With respect to equitable distribution, we do know that the trial court failed to comply with section 61.075 of Florida statute. The trial court awarded all the asset to the former husband, nothing to the former wife. And we cannot call this an equitable distribution, because there is nothing equitable about a scheme that awarded 100% to one party and nothing to the other. Now, we understand that, hey, opposing parties' position, well, hey, if there's a default, then, hey, the trial court is within its right to award everything to the former husband. But if you take a look at the pleading, the facts were not sufficiently pled to require 100% of all the asset awarded to the former husband. The former husband did not ask to be awarded everything 100%. So this is pretty much the problem we have with this final judgment. In fact, under the law, this court in Poham stated that if the trial court decide to divide marital asset in an unbalanced manner, the trial court is required to support its decision to say why it is appropriate. In this case, the trial court didn't do that. In fact, simply the trial court awarded everything to the former husband. It's also awarded the former husband a money judgment. But we do know that the $900,000 you were talking about was money unavailable at the time of the final hearing or even before the party filed for decision of marriage.
Mr. Florenson, you're down to 5 minutes, so you can, that's your rebuttal time. You can use them now or then, but it's up to you.
Okay. Okay, yes, Your Honor. To summarize, regardless of the default, the trial court was required to address the form of the equitable distribution. This is this is a March 2014 case by this court. It says even if there is a default, the trial court is required to address the form of equitable distribution. In this case, the trial court failed to make findings as to why it is appropriate to provide everything to the former husband, nothing to the former wife. Thank you.
Thank you.
Good morning, may it please the court. Scott Beatty on behalf of the Appellee, former husband Philip Smith. Can appreciate when there are 8 issues on appeal that there's a lot of ground to cover. I will do my best to address them in the order that they were presented by counsel, just to facilitate the discussion easier. On the issue of jurisdiction, the Florida Supreme Court's made it very clear in the Go-to-Makers case that dissolution actions are not subject to the local action rule. That should solve that issue. What the court did in this case with respect to the Montana property, different than the Florida property, was it compelled the former wife to execute a deed. It used its in personam jurisdiction over the former wife to compel her to execute a deed. The record shows Mr. Smith had to file actions in Montana to further the transfer of that property. But cases, the Dusasoy case that this court has ordered, the Gill case out of the 3rd DCA, the Parra case out of the 1st DCA, all of these cases dealt with the power of a court in a dissolution case to compel one of the spouses to transfer property using the in personam. And the judgment itself entered in this case said, with respect to Montana, Mrs. Smith, you need to transfer that property. With respect to the Florida property, it said this judgment itself stands as the conveyance. That's the difference between those two. With respect to the issue of striking the pleadings, the standard, of course, is there a basis in the record that would support what the trial court did? And we submit to this court that there is. There are at least 10 instances in the record that support what the trial court did. And those are 10 orders that were disregarded by Ms. Smith. 10 different orders throughout this litigation, culminating in an order of contempt and a writ of bodily attachment. The argument that's been raised in the briefs by Ms. Smith is that, oh, she did comply. She did comply. These were the same arguments that were made by her counsel to the trial court every single time each one of those 10 motions was raised, and they were rejected by the trial court. The trial court said, I find you have the ability to pay. I find you have the ability to get additional documents. The documents that she produced in December of 2012, before the court struck her pleadings, were the same exact documents that the prior counsel in 2011 had produced. And then maybe it's an oversight, I don't know. They also reflect documents that were produced in March of 2013, which of course is after the order was entered striking her pleadings. The fact of the matter is she thumbed her nose at the court, and when the court said you need to come back, you need to comply, you need to pay because I've made a determination that you have the ability to do those things, she left. It's no coincidence that she left and went back to Slovenia, where she's from, after the court entered an order of contempt. And it's no coincidence that she left and fled the country after a writ of bodily attachment was entered. The record supports what the trial court did. The court cannot find that reasonable people would differ on this issue in order to sustain an abuse of discretion. In fact, Judge Northcutt, Judge Black, you were on the panel on a previous appeal that Ms. Smith filed on the temporary fees. There was a motion that was filed by Mr. Smith to dismiss her appeal on the basis that you cannot ask the court for relief and at the same time completely disregard and thumb your nose at court orders. And you two were on the panel. The court granted the motion to dismiss, and that appeal was dismissed. Again, there is no question that there is record evidence here supporting that the trial court properly exercised its jurisdiction. And with that default, it affected what occurred later at these at the trial in this matter. After the default was entered, the trial judge said, I'm going to set this matter for hearing. Not 2 days before that hearing, it was more than 2 weeks before the hearing, the wife's attorney filed a motion to withdraw. The reason the wife filed the motion to withdraw is she said, I cannot get cooperation from my client. The transcript of that trial is in the record. She said, I demanded her to come. So you've got the court telling her she has to do things. Her own attorney demands her presence, and she ignores it. And the attorney was put in the position to say, how am I supposed to represent somebody who won't even comply with my requests, let alone the court's requests? The motions to continue, which are not part of this record, I'm not suggesting that they weren't filed, but they're not part of this record, were filed by Mrs. Smith pro se. Her attorney said, I can't argue those to you, Judge, because I don't know the contents of whether or not they're true. But that attorney also said she knew that Ms. Smith was compelled to be there for this trial. And again, I demanded that she come, and she didn't come. With respect to the issue of the jury trial, again, Mr. Smith did demand a jury trial. And then when we had the trial, Mr. Smith proceeded with trial. Mrs. Smith, through her counsel, proceeded with trial. There was evidence taken. There was testimony given. There was never an objection to the non-jury setting. And the cases that we've cited in our brief, Chapre, Murrow, Del Reyna, all say that participation in a non-jury trial constitutes a waiver of the right to that jury trial. The final issue that was discussed that I do want to talk about, because I don't think this is really developed well in the briefs, is this issue of the compensatory award to the wife. The record evidence in this case shows all of the assets that we're talking about were pre-marital assets. There's no evidence that there were any marital assets. Everything belonged to Mr. Smith prior to the marriage. The pleadings made the claim that they were transferred to Mrs. Smith because Mrs. Smith said, your kids are out to get you. And Mr. Smith testified, not just based on the pleadings, testified at that trial that he was told by Ms. Smith, transfer it to me to keep it away from your evil children, and then I'll go ahead and give it back to you. So there is a presumption that there's a gift, but based on that testimony, we overcame that presumption, and that's why the court did not award any of that to Ms. Smith, because there was no marital property with which it could make a distribution. The other issues, I believe, are adequately argued in the brief, and will rest on our brief, but we ask the court to affirm the trial court's judgment. Thank you.
Thank you, Mr. Beatty.
Now, with respect to the subject matter jurisdiction, we do know that the amended final judgment on paragraph 50 stated that the April 22, 2011 deed from the husband and wife to the wife of the Big Sky workshop is void due to the husband's lack of capacity and the wife's undue influence, fraud, and coercion. Now, if those property were awarded to the former husband based on equitable distribution, we don't believe that there was a need to make a finding regarding fraud, coercion, undue influence. So the distinction between awarding asset based on in-personam jurisdiction is that it has to be incidental to the divorce proceedings. But here, there's no question that these are legal claims that could have been brought independently. Opposing counsel stated that Gill should dictate the result of this case with respect to subject matter jurisdiction. But we disagree. The reason is that in Gill, the trial court divided asset equally between the parties. But more important, in this case, nothing was awarded to the wife. But more important, in Gill, there were no legal claims. It was just the divorce. And then they asked the trial court to distribute properties, all properties of the parties. But here we have legal claims, and the trial court made findings regarding those legal claims. So this is the important distinction between this case and Gill. Gill is different from this case for that reason. With respect to the discovery violation and the striking of pleadings, our position is that striking her pleading in interim default was too harsh, because they admitted that they received documents, and the record shows that the former wife attended the deposition. She had to leave the country because she was ill, she was sick during the deposition, and she provided medical documents or evidence to support her position. Now, the jury trial request was not waived because the wife was not there to present objection, because the record shows that the former counsel for former wife stated former wife thought that counsel already withdrew, so she asked the court to continue the case. And we do know that the former counsel for former wife was there primarily to withdraw, not to present a case. And she didn't put a case. So, under normal circumstances, if the former wife was present and she did not object to the trial to go without a jury, yes, there could have been a waiver. But in this case, she asked for a continuance, a short continuance, and even her counsel said that she was not in any position to continue representing her. She was not in good conscience. She could not represent her. She could not put a case for her. Now, we cannot punish a party because her counsel said, she could not represent her, and she wanted to be there. She wanted to be there. She said that she wanted to be at her divorce proceeding, but she was not allowed to be there. In fact, the trial court thought that hey, she doesn't have a say-so in this matter. Right there, you have a potential due process violation, because a party has a right to be present at her divorce proceeding. That party, Mrs. Smith, has a right to receive notice reasonably calculated to apprise her of the matter and a meaningful opportunity to present objections. She was not given that opportunity in this case.
Mr. Florentin, you're right at your 5 minutes, so you need to wrap up.
Thank you, Your Honor. In this case, we respectfully request the court to vacate the writ of bodily, to quash the writ of bodily attachment, and to remand the case for a jury trial on the legal claims, and for the trial court to make factual findings with respect to equitable distribution, and to, at the very least, award the wife a share of the marital asset and liability. Thank you.
Thank you both. Thank you both very much. Court will be in recess for 15 minutes.
We've talked, we all put cases together, never physically met. I don't know, did we physically meet then?
I'm gonna run it back.
Hockley case?
Yeah.
Did we ever meet in that case? Or you participated in the mediation? Okay, it's been so long.
And then I got pulled.
I referred you a little matter of the real estate. Try that case, that divorce case. That case in Hockley is still in bankruptcy. Or did you know it was even in
I knew it was in bankruptcy because I would.
It's still there.
Periodically get notice.
My clients are long gone.
You have the contract, right?
Good to see you again, and I
Good seeing you.
enjoyed your argument.
Well, thanks.
Here.
Oh, yeah. Oh.
so I'm gonna assume it was from this morning.